This is LAFQ versus Stay Dry Basement Waterproofing Inc. et al., docket number 21-304CB. And this is the time set for hearing on the plaintiff's motion for entry of an order appointing a receiver. And I'll take appearances, please. For the plaintiff first, please.
Your Honor, Dennis Haley appearing on behalf of LAFQ, and also appearing are Richard Prznicki, who is the loan officer in control of this file, and Eric Chagnon, who is the suggested appointee as receiver.
Okay, and then is that you, Mr. Brown?
Yes, ma'am.
Okay, now you can only appear here on behalf of yourself individually as a defendant. You cannot represent a company. You understand that, right?
Yes, ma'am.
Okay, thank you.
I did.
Then, I'm sorry?
I did have a conversation with Rick just a few short minutes ago, and we have a solution, Judge.
Okay, very good. I'll turn to Mr. Haley then and see what he can tell me.
Yes, ma'am.
Your Honor, it's my understanding that Mr. Brown wants to proceed with the closing, and that he has a prospective buyer, and that he will pay from those proceeds to LAFQ the sum of $208,064.61. However, to put some parameters and some control on this, we also wanted understood that the court will enter the order that was attached to the motion with a couple of small changes if that closing doesn't occur within 7 days. So what Mr. Brown has to do is acknowledge to the court that the receiver is appropriate, that the court has cause to do it, that he doesn't object to the terms of the order, and that the court will enter that order within 7 days if the closing at $208,064.61 doesn't occur.
Okay, so Mr. Brown, you heard all that?
Yes, ma'am.
So did you see this motion and that they want to appoint this receiver who's present here, Mr.
Yes, ma'am.
Okay, and that's
Yes,
okay
ma'am.
with you?
Yes, ma'am.
Did you see the order that Mr.
Yes.
Haley attached? Okay, it has all the powers of the receiver?
Oh, yes, ma'am. We don't have, yes, ma'am.
And you're in agreement as well?
Yes, Your Honor.
And there certainly is cause for the court to appoint a receiver in this case, agreed?
Yes, Your Honor.
Okay, then if you want to, oh, I have that actually. Do you want to sign what you, do you want me to sign what you submitted then, Mr. Haley?
Your Honor, there would be two changes, and perhaps the best way to proceed would be for you to sign that order and let me do a supplement, which would include a legal description, which I neglected to attach, and a copy of the bond, so that that's of record as well. And the execution of the order, Your Honor, is, as I understand it, going to be held in abeyance pending the closing. So,
well, then couldn't you just send me an order? I mean, we have 7 days, right? So yes. Can't you just send me an order with the legal description and the bond? Absolutely. Okay, and then I will, sign that as needed.
Okay, Your Honor. Your Honor, could I just, there's sort of a list of findings under the court rule. I'm wondering if I could recite those to the court. It may be adequate with this stipulation, but because they're a part of the court rule, the court has already received the acknowledgement that good cause exists for the appointment of the receiver under MCR 2.622(b). The court is also, I think, required to make the finding that the receiver has sufficient competence under MCR 2.622(b)(5), and that would require two things: one, the management skill, and the other, the experience in selling real estate. The court should have an affidavit attached to the motion, and that has both the personal information about Mr. Chagnon and also the history of the company. Mr. Shagnon is a third in control in the company, where he heads the accounting function, the property management function, and manages the property managers. He has approximately 50 properties with about $1,500,000 of square feet under his direction. With respect to brokerage services, Mr. Shagnon is a co-broker, or excuse me, an associate broker. And in 2019, the company had closed sales of $57.9 billion. In 2020, closed sales of million. Closed sales in 2020 of 36 million. And in 2021, year to date, closed sales of 18.8 million. So I'd ask the court to find that the request receiver has sufficient competence under the court rule.
Okay, well, I've never done that when there's no objection and it's stipulated, but you're saying that I should find that as opposed to Mr. Brown indicating he's in agreement with it.
He could verbally indicate he doesn't object to the competence. That's true, Your Honor. That might be an easier way to go.
Okay, Mr. Brown. Mr. Brown,
No,
there's another
yes,
issue
Your
here.
Honor.
There's another issue here, and that is not only whether a receiver is appropriate, but whether this particular receiver has the type of experience and skill to perform these duties as a receiver. Do you take any issue with that? Are you in agreement that he does?
Yes, Judge, I'm in agreement that
Thank
he's
you very
okay
much.
to be the receiver. Yes, ma'am.
Thank you. And I would indicate
Yes,
that
ma'am.
I also reviewed his resume that was attached, and I would make the finding, as Mr. Brown has already agreed, that he has the requisite skill and experience and is qualified to act as receiver in this case. Anything else, Mr. Haley?
Your Honor, MCR 2.622B5E requires a finding that the receiver is not disqualified, and I think by his affidavit, he's indicated that he is disinterested. And so either by or with Mr. Brown's acknowledgement and the court's finding, we would ask the court to incorporate that into the record.
Well, I find that the receiver is disinterested, and so he has no conflict, he's qualified.
Your Honor, finally, the bond that we're posting is in the amount of $50,000. It is relatively nominal, but there is no cash being handled. And so I'd ask the court to approve the amount of the bond at $50,000.
Yes, I approve the amount of the bond at $50,000.
And then finally, Your Honor, the change, in addition to attaching the bond and the legal description, I was going to add a paragraph to the end of the order that when the court approves Mr. Shagnon's fees as submitted, that the bank be permitted to add those expenses to the amount secured by the mortgage. That, of course, becomes moot if the sale occurs, but if the sale doesn't occur, we would seek to add that to the mortgage, and would ask Mr. Brown to acknowledge that he agrees that that's an appropriate expense secured by the mortgage, and ask the court to so find.
Mr. Brown, he's talking about adding on the expense of the receiver.
I mean, that's fine. Yes, ma'am. I have no, yes, Your Honor.
All right.
Yes, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Mr. Haley?
Thank you, Your Honor. Thank you for making the record. I think that's perfect.
Sure.
I just want to, yes, I just want to get the deal done. Yes, ma'am.
I understand. It
Your
sounds
Honor,
like
may
it's
I?
headed that.
I'm sorry, Your Honor, just one more matter, just so that, and I'm sure the court inquired about this initially, but Mr. Brown, I'm sure understands that he is doing this without the benefit of counsel, and that he intends to be bound by this to the extent that he's representing himself. And I'm not sure what we do about the representation of the corporation, the corporate entities, but I guess we have the order that we can enter if he doesn't perform.
Well, yeah, I mean, the corporate entity has not appeared and has not objected or not participated. Only Mr. Brown individually has, so.
I can explain the reason why, but I think it's a moot point.
It's okay.
But I haven't got any representation, Your Honor, so I can close this deal today and get this done. If I were to hire a representation, it would cost more money and add more. So I just, on my word, I want to just move forward and close this as quickly as possible. If they stand by the 108, not try to add any more fees on this, I'm totally good.
Okay.
208.
And
208.
change. That's what we agreed on, right, Rick?
Right, yeah, you said 108, David. So.
Oh, my bad. My apologies to the court and to the councils.
Your Honor, thank you.
All right, thank you. And that will
Thank you.
conclude our hearing.